Hello everyone, I'm Aratrika Bhaumik and I welcome you all to another episode of Courts This Week on LiveLaw, where we update you about all the significant legal developments that took place all through last week. We will begin with developments from the Supreme Court of India and then move on to High Courts and other subordinate courts. If you like our content, please do support us by liking and subscribing to our YouTube channel. Let's begin. A constitution bench of the Supreme Court has ruled that a judgment delivered by a larger bench will prevail irrespective of the number of judges constituting the majority. To illustrate, the judgment of a 7-judge bench delivered by a 4:3 majority will prevail over a unanimous 5-judge bench. A 5-judge bench comprising Justices Indira Banerjee, Hemant Gupta, Surya Kant, M.M. Sundaresh and Sudhanshu Dhulia gave this ruling while answering the second issue in the case titled Trimurti Fragrances versus Government of NCT of Delhi. The bench pointed out that under Article 145 Clause 5, the concurrence of majority judges is viewed as judgment of the court. The Supreme Court has referred to a 5-judge bench the issue relating to hearing the accused before imposing the death penalty on him. A bench comprising Chief Justice of India, U.U. Lalit, Justices S. Ravinder Bhatt and Sudhanshu Dhulia noted that there were conflicting judgments regarding the grant of hearing to an accused before imposing the death sentence on him. The bench also noted that in the Bachchan Singh case, the court had mandated separate hearing of the accused before imposing the death penalty as per the recommendations of the 48th Law Commission of India. The bench also took into consideration that in all cases where the death penalty is a choice, it is necessary to place mitigating circumstances on record. However, the mitigating circumstances relating to death sentence can be placed on record only after the conviction. The Supreme Court has upheld the validity of the Haryana Sikh Gurdwara Management Act of 2014 and dismissed the petitions challenging the constitutionality of the act. A bench comprising Justice Hemant Gupta and Justice Vikram Nath delivered the judgment in a writ petition filed in 2014 by a man named Harbhajan Singh, a member of the Shiromani Gurdwara Prabhantak Committee (SGPC). In 2019, the SGPC had filed a writ petition challenging the act. The petitioner had challenged the Haryana legislation by arguing that the state legislature lacked the power to create a body for Gurdwara management, as such power was reserved only with the parliament. After a marathon hearing for a period of over 10 days, the Supreme Court has reserved its judgment on a batch of petitions challenging the Karnataka High Court's judgment, which upheld the ban on wearing of hijab by Muslim students in educational institutions. A bench comprising Justices Hemant Gupta and Sudhanshu Dhulia heard the matter. During the hearing, Senior Advocate Amadi underscored that the state should prioritize the education of girls and further remarked, and I quote, "It is strange that the state, which should be concerned about educating girls, is concerned more about discipline and is enforcing this, which can lead to denying education to girls." The Supreme Court of India has observed that fixed term sentences exceeding 14 years can be awarded in appropriate cases to strike a delicate balance between the victim's plea for justice and rehabilitative justice for the convicts. This fixed term sentence can only be imposed by the High Court or the Supreme Court and not by the trial court, the bench comprising Justices Sanjay Kishan Kaul, Abhay S. Oka and Vikram Nath observed. The Supreme Court has set aside an NCDRC order that directed a hospital to pay compensation to a woman who delivered a child despite undergoing the tuberculosis procedure. In this case, a woman underwent the procedure twice, though both the procedures remained unsuccessful. She gave birth to a male child in 2003. She filed a complaint before the District Consumer Disputes Redressal Forum alleging medical negligence on account of the failed surgery. The Supreme Court, taking note of the law laid down in the decisions relied on by the appellants, allowed the appeal by setting aside the NCDRC order. The Supreme Court has clubbed and transferred to the Delhi police all the FIRs registered against Times Now anchor Navika Kumar, over the controversial remarks made by former BJP spokesperson Nupur Sharma on Prophet Muhammad during a TV debate moderated by her. A bench of Justices M.R. Shah and Krishna Murari ordered all the FIRs registered against Navika Kumar to be transferred to the Intelligence Fusion and Strategic Operations, that is the IFSO unit of the Delhi Police. Pertinently, the court also ordered that no subsequent FIRs or coercive action can be taken against Kumar for a period of 8 weeks so that she can avail remedies in the interim. The Bombay High Court has refused to direct the BMC to consider regularizing 300% additional construction at Union Minister Narayan Rane's Juhu residence. A division bench of the High Court said that the corporation is bent upon considering the application for regularization irrespective of the provisions of law. However, allowing the petition would be an encouragement of wholesome unauthorized construction, the High Court said. The court was dealing with the second petition filed by the Kalka Real Estates Private Limited, a closely held family concern of Rane, seeking permission for the BMC to consider a second regularization application under Section 44 of the Maharashtra Region and Town Planning Act. In connection with the appeal seeking restoration of alleged temples in Delhi's Qutub Minar complex, a Delhi court has dismissed an intervention application filed by one Kunwar Mahendra Dhwaj Prasad Singh seeking right over the territories running between the river Yamuna and Ganga from Agra to Meerut, Aligarh, Bulandshahr and Gurgaon. Additional District Judge Dinesh Kumar passed the order after hearing Advocate Manohar Lal Sharma for the intervener, Advocate Subhash Gupta appearing on behalf of the Archaeological Survey of India and the council appearing for one of the appellants. The matter has now been listed for hearing the appeals on October 19th. ASI has contended that Singh claimed rights for large and vast areas in several states. However, he was sitting idle for the last 150 years without raising issue before any court. The Bombay High Court has ruled that in an agreement executed by both the parties which contained independent terms and conditions, a mere reference to a proposal containing an arbitration clause which was unilaterally signed by one party would not amount to an arbitration agreement coming into existence between the parties. Justice Manish Pitale held that for an arbitration agreement to come into existence, there must be a document incorporating an arbitration clause or agreement which is executed by both the parties, showing a consensus ad idem between them. The Delhi High Court has ruled that mere presence of a decree of restitution of conjugal rights against the wife does not disentitle her from claiming maintenance from her husband when it is due to his own conduct that she is not able to live with him. Emphasizing that every case seeking compensation in matrimonial disputes have to be dealt with according to its individual facts and circumstances, Justice Swarana Kanta Sharma said that every judgment, though filed under the same provision, cannot be painted and penned with the same stroke of a brush. The court therefore held that mere existence or non-compliance of a decree of restitution of conjugal rights by itself would not debar or disentitle the wife under Section 125 of the CRPC from getting an order of maintenance. The Kerala High Court has strongly condemned and initiated suo motu proceedings against the leaders of the Popular Front of India after noting the illegal call for flash hartal in the state, which was earlier banned by the court. The PFI called for dawn to dusk hartal in the state following the arrest of its leaders by the NIA. A division bench consisting of Justice A.K. Jayasankaran Nambiar and Justice Muhammad Niaz CP observed that stringent action must be taken against the violators of the High Court order. Thank you. Keep watching Courts This Week on LiveLaw for more such updates. See you next week.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.